Good evening. Welcome to the City Council special meeting this Thursday evening, April 17th. I now call this meeting to order. City Clerk, please call the roll.
Certainly, Mayor Newsom. Councilmember Diaz-Nash.
Here.
Councilmember Svirko-Goditsky.
Here.
Councilmember Fernandez.
Here.
Deputy Mayor Lorraine.
Here.
Mayor Newsom.
Here. At this time, I will ask the City Clerk if any notifications or requests for virtual meeting participation have been received from any members of the council due to just cause or emergency circumstances.
Yes, Mayor Newsom, we have received a request from Deputy Mayor Lorraine.
Thank you, City Clerk. Deputy Mayor Lorraine, would you please address the council?
Yes, thank you, everybody. I am requesting to participate remotely under just cause circumstances as I am experiencing a contagious illness, which prevents me from attending in person. I confirm that I will have both audio and video on throughout the meeting, the entire meeting, and there are no individuals over the age of 18 present in the room with me.
Very good. I hope you feel better, Mr. Deputy Mayor. I call for a motion to accept Deputy Mayor Lorraine's request to participate remotely.
So moved. Second.
And before you vote, if I may just interject, so based on what Deputy Mayor Lorraine has stated, and also based on the fact that we have, for the record, we have a quorum, majority of the city council physically present in council chambers, and Deputy Mayor Lorraine has not exceeded his allowance of the number of times he can use just cause for this calendar year. So based on all of those findings, the council can vote on the motion.
Thank you. Can we take a roll call, please?
Certainly, Mayor Newsom. Councilmember Fernandez.
Yes.
Councilmember Diaz-Nash.
Yes.
Councilmember Svirko-Goditsky.
Yes.
And Mayor Newsom.
Yes.
Motion carries 4-0.
We're excited to be here in person with options for those who choose not to be in person to participate virtually. There are several ways to participate. For those attending in person, please complete a yellow request to speak slip and hand it to the clerk. If participating remotely, please raise your hand using the raise your hand feature in Zoom, and you will be called on at the appropriate time. If calling in via phone, press *9 to raise your hand, and when called upon, press *6 to unmute. These options for public comment will remain available until I close the public comment period. The item tonight on the City Council special agenda, we'll have two closed session items, conference with legal counsel, anticipated litigation, and item 2, conference with legal counsel, anticipated legal litigation. Now, before we begin and convene the closed session, City Clerk, do we have requests to speak on this item?
Yes, Mayor Newsom. And if I may, just to clarify, we have two closed sessions on the agenda for tonight's special meeting. Before we convene to closed session, we will be taking public comment for both items together. So we do have two requests for organized presentation, which as per council adopted rules and procedures are individually 5 minutes per organized presentation. However, tonight we will be taking both items collectively. I've received two organized presentations, one from Jeff Adams, representing community members from San Mateo Park, and Ariel Strauss from No Sellout Group. And I have no additional requests to speak. So we will begin with our organized presentation, and I will invite Jeff Adams to unmute your mic.
Great. Well, thank you very much, City Council members, for giving me the opportunity to speak this evening. And I just want to say on behalf of all the affected residents in San Mateo, and especially those in San Mateo Park, we are certainly very grateful. And thank you, each of you, for taking the time this evening to hold this special session to talk about such an incredibly important issue. We are all here tonight for one simple reason. The city staff was negligent in performing one of its most basic duties with regard to the 5G application process, and that's handling these in a timely manner. And as we know, as a result of that negligence, the Crown Castle issued and served the city with a deemed approval letter, and that letter asserted that the 5 permits in question were deemed approved as of February the 17th. But rather than, and what that means, by the way, is they could have shown up at any of those facilities on February the 18th and begun installing them because they had a validly issued permit. For some reason, rather than contesting that immediately, the city attorney chose to concoct a plan to request an extension of the tolling date and essentially push out having to confront this issue. And that created two very important and is troubling for two very important reasons. First of all, whether or not the appeals are valid has no bearing on whether or not we have the deemed approval status for these permits. But secondly, it also created a terrible backdrop and environment for each of these appeal hearings. And Crown Castle agreed with that when they stated that at the beginning of each of the appeal hearings. And so importantly, Crown Castle views themselves as having issued permits completely unrelated to our appeal processes. And that flawed and intelligent way of thinking is exactly what got us here in the first place. These people have asked why, if we went through our approval processes and these permits were approved by the city, why is removing the deemed approval letter so important? Well, it's important and critical for three reasons. First of all, the letter gives Crown Castle a valid issued permit. So as long as it's in place, Crown Castle has a valid issued permit due to the city's negligence, and only the city can contest that. So that removes a very basic right of the residents, which is to pursue remedies for these faulty applications. Secondly, the city has significant, incredible financial liability as a result of the city's negligence. And I want to make a couple of points on this. First of all, the residents of San Mateo Park are extremely pissed off and frustrated given the way the city has handled this whole process and how they basically ignored and rebuffed the residents' attempts to collaborate. So it's a very bad backdrop. Secondly, the fact that these permits have been approved under the deemed approved status means the city is not covered under and it's not indemnified because of the city's negligence. And that means any resident that thinks their property value has been impacted is free to pursue remedies against the city and damages against the city. So if you think there are 5 of these permits across San Mateo Park, if you take just a couple of properties on either side of the street of each of these facilities, you very quickly are at 25, 30, maybe as many as 40 properties who could say their property value is impacted. The average sale price or average home value of a home in San Mateo Park is just under $4 million. So that's north of $100 million of value exposure that the city has should residents pursue damages for these negligent permits being in place. And I don't think the city wants to be on the side of arguing that putting these facilities in front of homes via a permit that was issued under the city's negligence, I don't think the city wants to argue that there's no impact to property values in that scenario. And lastly, removing this letter is critical because it's the right thing to do. We're in this situation because the city made a mistake. And when you make a mistake, you own up to it and you face it and you confront it. You don't turn away from it. And that's what the city attorney has tried to do. He was hoping that this issue would never come up because all of the appeals were to be denied. And the right thing to do is to confront this issue and to confront Crown Castle to take care of these two important issues. Give the residents their rights back. And secondly, make sure that the city does not have this financial liability as long as this letter is in place. So I would just close by saying and asking the city council this. It's a very simple request. Direct the city attorney to ask Crown Castle a very simple question. Do you, Crown Castle, agree with the city of San Mateo's position that the 5 deemed approved permits are now validly issued, given that we, the city, went through our permit approval, and that these appeal processes were proper, and that therefore the deemed approval letter is moot? Have them ask Crown Castle that question. If Crown Castle says, yes, we agree, then they would happily withdraw the letter and the permits are in place. If Crown Castle disagrees or refuses to respond, then you have your answer and you should direct the city attorney to pursue litigation to make this issue and address this issue and have the letter go away. I'll pass there over to Ariel. Thank you.
Thank you, Jeff. We will now move on to our second organized presentation from Ariel Strauss. Ariel, please go ahead and unmute your mic.
Good evening. Am I coming in clear?
Yes, you are.
Thank you. Good evening, Mayor, Deputy Mayor, members of the council. Thank you for taking the initiative to make time to uniquely hold this meeting tonight to support the rights of residents and seriously consider their concerns. We very much appreciate you all taking your representative responsibilities so seriously. My name is Ariel Strauss. I'm representing several wireless permit appellants. And I want to give you a plaintiff's view of the relevant background for legal issues I expect you will be discussing in closed session. Under state law, the submitting of a deemed approved letter itself automatically and instantly effectuates approval of a wireless permit. In the language of Government Code Section 6564.1, the permit, quote, shall be deemed approved if, end quote, various requisite actions are taken, as Crown Castle asserts they have in its February 18th letter. Then, and only afterwards, the city gets 30 days to contest that in court. But the approval, it kicks in immediately. Here's how Crown Castle concluded their deemed approval letter. Quote, please be advised that the application and all other approvals necessary for installation work are now deemed approved, and Crown Castle possesses a permit at law with which it may lawfully proceed to construction, end quote. Note the word now. According to the letter, the permits were effectively issued immediately on February 18. In its second letter of March 9th, Crown Castle wrote to, quote, allow sufficient time for the CIC hearings to take place. Crown Castle agrees to toll the city's 30-day periods for challenging deemed approved status, end quote. Read this carefully. Crown Castle did not delay the effectiveness of deemed approval itself. They only extended a deadline for the city to sue to contest it. The city now has until April 21st. On April 9th, at the SNI appeal hearing, Crown Castle's representative read the same verbatim prepared statement as on prior appeals, and it is as follows, quote, on the 18th of February, the applicant provided a notice of deemed approved status. And while our rights to enforce the deemed approved status under state law remain intact, we are here tonight in good faith to participate in the city's process just as we have in the past, end quote. Of course, good faith is a terminology from the quote. But take them at their word. They said their rights remain intact. They are claiming to have already a permit in hand. They have never wavered from that position. As a result, Crown is all set to argue that regardless of the completeness or accuracy of their application, the deemed approved letter already granted them permits as a matter of law. Unlike going to court to appeal the SNI Commission decision, which residents can do by statute, only the city is given the ability to contest the deemed approval notice because the statute says the city or county may seek judicial review. If a resident sues to overturn the SNI decision, Crown Castle can colorably say the permit was already independently issued for the letter, and Crown never waived that right. And since the city did not sue within the prescribed time period, it is finally and irrevocably issued. No one can contest it. This whole barrier and limitation on residents' rights is solely due to staff error. As you're aware from the staff slide included in my email attached to the agenda packet, it is totally and unambiguously the right practice, specifically to avoid the problem we're discussing now, for the director to approve permits on a schedule that allows sufficient time for the entire process to play out. Staff were trained to do this, but recklessly did not. Generally, the applicant who submitted the application causing the city to act and which stands to gain from the permit is appropriately responsible for all the costs incurred by the city if the city gets sued over that permit. But standard condition 12 for permits has an exception. Quote, permittee's duty to defend and indemnify should not apply to the extent such claims are caused by the sole or active negligence or willful misconduct of the city, end quote. That means that missing the deadline, which is plainly grossly negligent, could void the indemnity and make the city on the hook for all legal costs if sued. And more typically, the city is categorically immune from damage suits arising from issuance of a permit. There is an exception, however, to that also, and it applies here. Government Code Section 815.6 declares, quote, where a public entity is under a mandatory duty imposed by enactment that's designed to protect against the risk of a particular kind of injury, the public entity is liable for an injury of that kind approximately caused by its failure to discharge a duty, unless the public entity established that it exercised reasonable diligence to discharge the duty. In this instance, staff have a mandatory duty to process applications timely to allow the city's design standards to be effectuated, and staff failed to exercise reasonable due diligence. The stated purpose of the city's wireless ordinance is, quote, one, ensuring the balance between public and private interests is maintained on a case-by-case basis, and two, protecting the city's visual character from potential adverse impacts of visual blight created and exacerbated by wireless communication infrastructure, end quote. If this purpose is frustrated by wrongfully issuing a permit, and the city's negligence makes it impossible to remedy it, residents will have a basis to the city for diminution in property value caused by the wireless installation that was wrongly approved, yet impossible to remove. Do you want to put that to a jury? Tonight's agenda notes the risk of 5 lawsuits because 5 appeals were filed. And as Jeff Adams notes, some appeals had more appellants, meaning multiple damage claims. But moreover, if Crown's Castle's letter remains in force, then the appeals at S&I Commission hearings were just a show, since the permits had already been issued by letter in February. And as your attorney can explain in more detail, this would make appealing futile in legal parlance. And as a result, even more neighbors that did not exhaust administrative remedies by timely appealing the S&I Commission to the S&I Commission would be able to sue the city for damages. And if one resident does it and prevails, you can expect a raft of additional suits to follow. Moreover, since these lawsuits are for damages and legal fees, not regulation of cell sites, they would not implicate any FCC preemption, and there's zero limitation on jury considering the economic harm of public perception of RF radiation. And I think any real estate agent will tell you that buyers do care. So even if fear of RF radiation is a reason that buyers are less interested in the homes adjacent to antennas as compared to other homes, if that diminution is occurring in the real world, that will figure into damages as well. And even if the city were to win the lawsuit, Crown would not cover the legal expenses of them doing so. So in addition to doing the right thing on principle protecting resident civil rights, getting Crown Castle Rescindent's letter is a good insurance policy to avoid the risk of negligence lawsuits. On the flip side, the city convinces or forces Crown Castle to rescind the letter on behalf of the residents, thereby remedying staff's negligence and enabling appellants to sue the city to overturn S&I Commission approvals. Those lawsuits are fully covered by Crown Castle indemnity. And because the residents will be seeking rescission of permits, the city would not be at risk of any damage claims. Moreover, getting sued by residents seeking to overturn the S&I decision is not actually a bad thing. And this may sound odd, but listen further. First, the city has no stake in getting wireless facilities built. That's Crown Castle's business, not the city's. Right now, there's legal ambiguity out there in telecom law. So win or lose, having a judge clarify that on Crown Castle's dime is a good thing for city administration of the wireless ordinance going forward. Second, if the residents prevail, what we have established is that wireless applicants are misinterpreting federal law, and they're using it to inappropriately override the city's own standards. And in the future, they'll have to provide more factual detail to justify exceptions. This too is a good thing for the city. It means the city has more power than staff currently believe, and it ensures that the new, more demanding wireless policy enacted last year is fully enforceable. As a result, I asked the city council to instruct the city attorney to obtain confirmation from Crown Castle that their letter is now moot. Given that the S&I Commission has rendered final decisions, there's no longer any need to expedite the permit process. The purpose of the statute was to enable applicants who had not obtained a final decision to force that outcome, and they have already obtained that. And in the event that the city attorney does not obtain that assurance from Crown Castle, to file a lawsuit on April 21st to overturn the deemed approved letter or to assert that it is void on the basis of the S&I Commission decisions. The city attorney committed to me personally and by email to recommend to the council to defend any S&I decision that overturned a permit and was opposed by Crown Castle. This implicitly means that the city attorney believes the city has defenses against the deemed approved letter, and those defenses would apply regardless of the S&I Commission outcome. As Jeff Adams said earlier, perhaps most fundamentally, however, only the city council can protect the rights of the residents. And it is an appropriate thing to do to guarantee those rights against Crown Castle's usurpation of them on the basis of a staff error. I hope that you will listen closely, discuss intently tonight in the closed session, and again, we'll come to the conclusion that the right thing to do and the most risk-averse thing to do is to convince Crown Castle, given the city is already in communication with them around current permits that are in process, convince Crown Castle to rescind the letter and threaten to sue them, then carry out that threat in the event that Crown Castle does not do so. Again, thank you so much for holding this meeting. I appreciate you all being here tonight. Thank you.
Thank you. Mayor Newsom, that concludes our organized presentations, and I have not received any requests for individual speakers, so that concludes our public comment period.
Okay, then we will convene to close session. Thank you for everyone for attending. We now reconvene from closed session and turn it over to our city attorney for reporting out.
Thank you, Mayor. There was no reportable action taken during the closed session. And separately, I will be following up with Mr. Strauss as to some related matters. Thank you.
Thank you. We now conclude this closed session. Good evening.